Welcome and thank you for joining us for this episode of Planning Successfully. I'm your host, Matt Theory. I'm joined in the studio again by my colleague, Rhett Peden, who joined me on the last show. Welcome back, Rhett.
Thanks, Matt. Good to be here.
In case you're joining us for the first time, Rhett and I are both shareholders with the law firm of Davis Matthews and Quigley. My practice focuses on business law, business litigation, and fiduciary litigation, and I also provide mediator and arbitrator services. Rhett, for those tuning in for the first time, can you give yourself a quick introduction as well?
I practice in the tax, estate planning, and business sections of the firm. Help clients with their estate planning, business planning, tax planning, owners of closely held businesses looking to sell their business or pass it on to the next generation. People like that I can typically help. Small businesses, closely held businesses, middle market companies, and getting right with Uncle Sam and hopefully helping them to protect and preserve their wealth.
Great. Thanks, Rhett. You can also find out more about Rhett and more about me at Davis Matthews and Quigley's website, which is www.dmqlaw.com. There you can also find more about the other practice areas of our firm and the other attorneys that we practice with. Today we're going to talk about business contracts. The goal is to help business owners understand what the difference between what they think the deal is and what the deal actually is, how these are not always the same, and how being proactive can help you avoid a lot of disputes and a lot of additional costs that may come down the road if things go awry. We're just going to sort of skim the surface on a lot of these issues, and there are certainly a lot more issues than what we're going to discuss. But Rhett and I have kind of composed a list of some of what we would consider to be the hot topic issues with respect to business contracts, and we wanted to start jumping into that right away with the fact that a contract really is more than a simple handshake. Businesses sometimes look beyond the details because they think that they know what they're getting into the deal for. And Rhett, you would have to agree with me that a lot of times the businesses, especially closely held businesses and smaller businesses, don't always get into the necessary detail that they should with respect to a business agreement.
Oh, all the time, Matt. I mean, we get people come in and they have no idea what's in the documents that they signed, or they don't have documents. I'll tell you, in law school, I had one class called Contracts. And, I think every class almost should have been called Contracts, because everything that we do in law is contracts, it's agreements between people, and, whether they have them, they don't have them, they think they have them. And we just spend a lot of our time working through contracts, trying to get people the best deals that they can and put it down into writing. So it ripples all through everything that we do as lawyers, and I don't care what type of lawyer you are. And the only person that's going to benefit from you not having a good contract is a litigator. So we've got some people that can help you with that too. But hopefully, if we've done our jobs the right way, sometimes you can't help but find yourself in that situation. But it's best to avoid that, and the best way to avoid that I know of is to have a good contract.
And Rhett, along those lines, a lot of folks. They go through a negotiation process orally with the other business, and sometimes they reach a deal, and they don't paper it, and they have an oral contract. Now, some contracts can be oral contracts and enforceable, and others cannot because of particular laws like the Statute of Frauds. But, what is it about an oral contract that provides you far less protection than what it would be if you would go ahead and put it in writing?
Right. So, so many people say, well, we had a handshake, or we had an understanding, or we saw eye to eye. Unfortunately, if you don't have that down in writing, it's really a he said, she said type of situation. And whenever that happens, people's memories get foggy. They don't recall exactly. They don't recall the same things happening. Their course of conduct may not be the same as what they thought they had agreed to. And so there are so many variables that could go awry that it's really difficult to pin down what exactly an oral contract is and what it means. And that's why it's generally preferable to have it in writing. That's why when someone comes into my office and says, we have an agreement, first thing I say, have you written it down? Where is it? Let's put that pen to paper and say exactly what you want it to say. And then it's my job as an attorney, and some of the best value that I can provide a client is to have them sit down and they say, well, we thought we had an agreement on this, but what happens if this happens? What happens if that happens? The two of you may, on each side of the agreement, honor the agreement, do everything that you can to make it work, but what if someone else is out there and does something that affects what you guys are doing? What if you're relying on a third party to pay a bill, and if they don't get paid, then you don't get paid. What happens in that situation? And a lot of times, unfortunately, even good business people, they haven't thought through those things and those details. But us as attorneys, because we see these situations happen so much, we see the fights that result from contracts that aren't thought through, hopefully we're able to help the business person anticipate what those issues are going to be, and then we can help deal with that and those contingencies in the written contract so that when those things happen, we've got some sort of procedure or some sort of idea about what's supposed to happen.
And Brett, that sort of dovetails really well into our next subtopic here, and that really is that clarity and completeness are your allies when you're dealing with a contract. Ambiguity, vagueness, and incompleteness are certainly your enemies. And a lot of contracts have what we refer to as either an integration or a merger clause that says this is the entire agreement. No other oral representations are a part of this agreement. You can't rely on anything that's not in this agreement. Basically, the gist of what that is whatever the document says is the deal, not what you think the deal is. And when you go through this, the clarity and ambiguity issue, a lot of the business deals, they know what they want when they're negotiating the deals. But if they're not careful and they don't document it properly, and what you say and what I say, we may think we're agreeing on something, but we both could be thinking about two very different concepts at that time, and get ourselves into a lot of trouble when I think we should be doing X and you think we should be doing Y, and we both thought that meant Z.
Right.
And that's, I think, a lot of that goes into the oral contracts, but it also spills heavily into the written contracts to make sure that both parties to the contract or all parties to the contract understand exactly what the deal is and why they're doing it. And there are a lot of spin-off considerations with respect to that, but the clarity and completeness being your ally in a written contract as well. The next issue I think we'd like to cover is why the other side's form contract is typically a bad deal for you. And Rhett, you've seen it and I've seen it. We've all seen it several times, very, very regularly. Someone will come in and they'll hand us a contract that they've already signed, that was prepared and proposed to them by the other party in the deal, and they don't like what it says, didn't read what it says, or don't understand what it says, and now they're trying to figure out what comes next. And wouldn't you agree with respect to the form contracts that other businesses present to people that they typically have a lot of hair on the dog?
Right. No, absolutely, Matt. And a lot of people are coming in with form contracts that you find them in a couple different varieties. You've got some people that come in, they have a form contract. The business that they may be trying to sign it with hasn't even given it any thought. They may have searched on Google and found some sort of contract, and then that's what they use. And if you found it on Google and you haven't looked at it and made any changes to it, it's probably not tailored to your situation. It's not going to get you where you need to go, and probably neither party is going to be served by signing something like that. Now, on the other hand, what you'll often see is you've got maybe a company that's put a lot of thought into their form contracts, and they don't even want to negotiate them because they've paid lawyers a lot of money to come up with all these provisions, and more likely than not, it's going to be drafted in a very one-sided manner, favoring the company that drafted the document. And I'm as guilty of this as anyone else, because if a client comes to me and says, we need a document that we're going to use for a lot of transactions, and maybe we'll tailor it for each transaction as it comes down the pike, but let's get some sort of form documents for the business ready. Well, I'm just going to draft that in favor of my client, and we're not intentionally going out there trying to harm anyone else or take advantage of the other side, but just in the nature of business of trying to protect your client's interest, what you're going to put in there may not be what the other side would want to see, and it's just going to be there to protect your client. And so when someone else comes along and they're asked to sign the contract that's been prepared for the business that actually drafted the contract, they're not going to have the protections in there that they would want to see, that if they went out and talked to an attorney, they might reasonably expect to have in there. So there are a lot of things in a contract like that can come back to bite you. Now, just wanted to touch on one other thing, though, Matt. You said a while ago about ambiguity in contracts and kind of that integration contract idea. That can cut both ways too. You've got a lot of people. They talk a lot. They go back and forth, and they think that may be part of the deal they've reached. But when you go and actually sign the contract in the boilerplate, and the boilerplate can broil you, but in the boilerplate, it's pretty common to have that integration provision you're talking about.
Sure.
And that happens in these form documents as well. So you can go back and forth and talk yourself blue in the face, but when you sign on that dotted line, all that other stuff goes away. It's not there anymore. It's as if it doesn't exist. And for the most part, you're within the four corners of the document. I can't tell you how many times I've had someone come to me and say, Rhett, this was the deal we had. And I'll look at the contract, and it'll have that provision in there, which it invariably has. And I say, well, I'm sorry, but that's not the deal that you struck. You may have thought you had another deal, but that's the deal you signed. And in a similar situation, we've got clients that'll come in. They may be a married couple that was married for 50 years. And she said, well, everything was supposed to go to me. And I don't doubt them at all. I believe that probably the husband, that's maybe what he wanted, to leave everything to his wife. But, what the will was written and what the will was signed, whenever that was done, for whatever reasons, husband may have signed that will at 25, 30 years ago, not knowing exactly what all was in there and what the lawyer had put in there. Times have changed, laws have changed, so it may not be the most appropriate document, doesn't get what he wants to have happened for his wife, but she'll come in and say, Rhett, I was supposed to get everything. And unfortunately, just like with a contract, with a will, we're in the four corners of the document. And unless you've got some pretty good reasons to bring in parole, what's called outside evidence or parole evidence that'll take you outside the four corners of the document, you've got to have a definite ambiguity. And ambiguity, Matt, doesn't mean you don't like what the sentence says or what the provision says. Ambiguity means
it's capable of more than one interpretation.
Exactly.
It's not certain when you read it exactly what's coming in.
So you and me, reasonable people, I hope, we could sit down and come to different opinions about what this sentence means. But just because mom comes in or the business person comes in and they don't like what that sentence says, it's hard to get them to understand, but that's not an ambiguity. Just because they thought it meant something else, if a third party comes in and reads it and they can kind of make sense of what it means, then you don't have to go outside the document to bring in extra evidence about what we talked about or what we may have intended or what this may have meant. Unless you've got some real striking ambiguity like that, I don't want to be that person having to argue about the ambiguity. I want to be the person who gets it right the first time.
And to take it a step further, when you're arguing about that ambiguity, you're almost always arguing that to a judge. And the judge is going to determine whether or not the judge can construe that contract without looking to outside evidence. So only after the judge looks at it, reads it, and determines that the judge can't figure it out, does the judge then allow this outside evidence come in. And usually that's the parties or the people involved in the process testifying about what they thought they were saying when they agreed to this, what their intent was, the party's intent. Obviously, the goal of contracts is to establish the party's intent in writing. And when the court's interpreting that, if the court can't figure out the intent from the document itself, then it will consider these other avenues of finding out that intent. But if the court can in any way interpret that without going to that outside evidence, even if it's not the construction that either party wants or anyone wants, the court's going to construe it as drafted.
That's right. And I think, Matt, this gets into something else I know you and I wanted to talk about, but kind of a good segue into that is about contracts of adhesion and about the relative bargaining power of the parties. And, that's something that you if as a consumer out there, as a contract of adhesion, which you may want to get into, you've got some protections that are provided for you at law. If you're a consumer and, you've signed the contract for that car and you're kind of at the mercy of what the dealer prepared.
Right.
But with a lot of the clients that I'm working with, if you're a service provider, you may be a sole proprietor, mom and pop, and you're signing a contract with one of the biggest Fortune 500 companies. You're still presumed to be a sophisticated business person capable of obtaining independent advice, and it doesn't matter that Coke and its lawyers or GE and its lawyers prepared the contract and gave it to you and you just signed it. You don't have any of those consumer protections that you may want, even though the relative bargaining powers are vastly different. You as a business person, even a small business person, mom and pop, sole proprietor, you're out there signing those contracts. You're bound by, and you're charged with the knowledge of what's in that document, even if you never looked at it, even if the other company was 1,000 times bigger than you. It doesn't matter. you're subject to whatever bargain you struck in that written document.
And you're right. That's completely right. So an adhesion contract is usually a consumer contract, and I think you mentioned a car as a car purchase as an example. And what we're really talking about when we say adhesion contracts is that the consumer, doesn't really have the opportunity to negotiate changes to that document. It's sort of a take it or leave it situation.
Right.
You want to buy this car, you're going to sign this contract. If you don't want a car, you're not going to sign the contract. But that's the only options you have. You don't have the option of, I'd like to change paragraph 3 to state something different than what it states on this document.
Unless you're my wife.
Fair enough. But in the ordinary consumer context, that's not an option.
I hope she's not listening.
So in the ordinary context, that's not an option for folks. That's really, you walk in, it's either take it or leave it. And,
right.
And there are consumer laws out there to protect consumers with respect to certain aspects of adhesion contracts. And I think what you're drawing the great distinction is in a business context, when you're a business owner, when you're operating a business and you're signing on behalf of a business for a contract, you're not getting consumer protection because you're not a consumer in the nature of that protection was designed for.
That's right.
You are considered to be someone that does have the ability to say, I don't like paragraph number 3 and I'd like to change it to say X, Y, and Z. And even if the bargaining power is not exactly even, you gave examples of Fortune 500 companies on the other side, which may tell you, no, we're not changing paragraph 3. We like it the way it is, and that's the way it is. Take it or leave it. They may even use the take it or leave it terminology to you.
Oh, I've heard that on more than one occasion.
But that doesn't mean that you lack the business sophistication to understand the agreement or the ability to make a business decision as to whether or not you want to enter into that agreement. So therefore, you don't have those protections. You're presumed to understand, and you're going to be stuck with the deal you sign.
And just also maybe a practical tip for people out there, to really have bargaining power, a lot of times you've got to make the other side believe that you're ready to leave it. Leave it might be one of the options. And if the contract is so one-sided, it may be best to just leave it. I've had people that I've counseled, and we've worked through a contract, and I wouldn't have wanted them to sign it, but they've gone ahead and signed it anyway. And sometimes it works great, but there are situations that come up where what we were worried about actually comes to pass, and they don't have the protections we need. And, that's also a negotiating strategy that some parties use, which is they tell the other party, take it or leave it. Or we're a big company, or we're XYZ, and we've never changed this before. Or another common phrase they use is, this is market. Well, yeah, there's some truth to that. There are some market and that means that this is what a lot of parties entering into this agreement agree to do after negotiation. So let's cut to the chase and let's just put the terms in there that everybody else uses. But at the end of the day, each contract is unique. And if you want to go to the mat over a term, there's nothing in there that's written in stone until you sign on the dotted line. So it may be market for everyone else, but it may not be market for your situation. And that comes down a lot to the relative bargaining powers that people have and how committed to their positions they are. And that's just left up to each particular negotiation and whether someone's willing to really think outside the box and do something that's a little bit different.
And to follow up on that, I think also, where you have those situations where someone is completely unwilling to consider any changes to the document, that not from a legal perspective, from a business perspective, may be a good indication to you as well as the other party to that contract how they're going to view that business relationship. If they're unwilling to concede anything in the document, it's very likely that they're going to play very heavy-handedly with you in the business relationship as well. And that should be at some point in time a red flag to you as the business owner of is this a must-have situation, or can I do something else and make it better? Play with somebody that's a little more reasonable, that's really going to play as a team as opposed to as a dominant factor in the relationship.
They're never going to treat you nicer than the day before you sign on the dotted line. That's just a fact.
I agree.
Yeah.
Okay, so some of these provisions I think that are in contracts that we probably should talk about for a second is a lot of contracts. People, when they enter the contract, they're not thinking about having a breach of contract action and having to go down the road of litigation. And And hopefully, in a lot of contracts, you never get to that. However, unfortunately, for parties, it occasionally happens. Someone will not perform what they said they were going to do, and you end up in a situation where you're pushed to a situation where you have to litigate some of these contracts. One of the things you have to look out for in these contracts are some of these terms that end up in the contract. For example, a waiver of defenses. For example, you can contract away some rights that you would otherwise have, and you may let's use an example of statute of limitations. For example, statute of limitations in the ordinary context says you have to bring a claim within a certain number of years or you lose that claim. Well, in a contract, you could shorten that statute of limitations. You may have a 6-year statute of limitations on a certain type of an agreement, and you can put in the agreement that if there's a breach, you have to bring your claim within 2 years or it's forever waived. So now you've taken what is a standard applicable law in the form of contracts and modified it through your contract. So you can change some of your other ordinarily granted rights through what you put into your contract.
Right. There's a whole background and web of law and statute and precedent that's out there that people get to go on, but a lot of that is subject to being changed in a contract. You can agree to do something different than what's in the law. Now, you can't do things that are contrary to certain fundamental things that are in the law. Those are unwaivable. But a lot of the rules, especially a lot of procedural rules, you can negate those, waive those, alter and amend those by what you say in the contract. And a lot of that is set up, like you said. A company might come in and say, we have this form contract and we've got this 2-year period or even shorter. I've seen that if you've got a claim, you got to bring it by that period of time or you forever waive your right to that claim. And it's because companies don't want to be in this position of having this long period of time. They've got to deal with this potential liability on their backs. They want to have the air cleared. And so that's a thing that a lot of people will agree to. But sometimes you may not know for a long period of time you discover that something has happened. And so you got to be careful that those periods don't begin to toll until you're actually able and capable and have reasonable knowledge that something might have happened.
Right. And there are a few other examples I think we'd like to cover and quickly would be limitation of liability, indemnification, personal guarantee, choice of law, and notice. Taking each one of those in quick order so that we can move on. Limitation of liability, you have certain rights to certain types of damages depending on what type of claim you have. However, in a contract, you can limit your liability. So if I'm contracting with you and I say, Rhett, no matter what I do in a breach of contract of this action, your maximum damages allowable are $500. Parties can contract away their actual damage rights. So you could have $5 million in damages and be limited to $500 in damages.
Right. And representing service providers, I like to see those limitations in there because you may have set up a company, had liability protection, and done everything right, but if you agree, especially if you put a personal guarantee into the contracts, which often service providers are called to make, and you don't limit your liability, you could have a deal go in there where you think you're going to make a couple $1,000s, but if something catastrophic goes wrong, suddenly you're on the hook for a lot more than that, and all that good work you've done in trying to limit your liability and set up a corporation or an LLC to protect yourself and your assets, all that could go out the window if you don't have some sort of protection and limitation of liability on that deal.
Right. And that ties, you tied personal guarantee and indemnification a little bit into that answer as well. I think that, sometimes the other party is going to ask that either the individual that's signing the contract guarantee performance and payment of that contract, or in addition to or in replacement of, there may be some indemnification requests in there, and basically that's just asking the party to sign on to say that if in the event that we get sued, you're going to pay for X, Y, and Z on our behalf, for example, attorney's fees, damages, and stuff like that. Choice of law, venue, and jurisdiction. I think this really comes into play more when you're dealing with companies from different states and, whose law applies. Does Georgia law apply? Does Tennessee law apply? Where's the case going to be had if there's a dispute? Does it go to Tennessee? Does it go to Georgia? And once you're in the state, which venue? So which court do you end up in? And you can, in a lot of situations, you can put in the contract where those disputes will be heard and what law will apply.
I think we've had some good success too in getting people in there to agree to Georgia jurisdiction. We've got a Georgia client dealing with people out of state, and if you ever do get into a situation where litigation becomes necessary, you're at a really big strategic advantage if you've already decided that you're going to be going to court, down the road, and someone else has to come from across the country. And so a lot of times, again, people aren't thinking there's going to be a breach, or they're not thinking in those terms. So they'll sign these agreements without paying attention to, where the dispute's going to be resolved. And suddenly they say, well, I've got to hire a lawyer in, New York and go, 1,000 miles and fly on a plane to settle this case or to go to court. And suddenly, you're in a position where you're maybe forced to settle when otherwise you would want to pursue the claim, just because the cost of pursuing it are going to be prohibitive because of where the forum is going to be.
Correct. Now, I know we only have about 5 more minutes, so I want to kind of touch on a few of the other issues that we had planned on discussing, but we're probably going to have to keep our conversations a little on the shorter side with respect to those. During the last show, we talked a lot about the corporate veil and the importance of protecting the individual business owner from separation from the company itself. Kind of a similar related issue to this is capacity to sign. And I think the issue that we need to discuss here is that this goes both ways. If you're signing a contract on behalf of the business, you want to make sure you have the capacity, the authority to sign on behalf of that company for that deal. And 2, when you're striking a deal with another company, you want to be assured that the person signing on behalf of that company has the authority to bind that company to the agreement that's being reached. And Rhett, talk a little bit about what happens if the person signing doesn't have authority, the problems that can arise.
Well, it gets back to agency issues and who's an agent for whom. And, especially, if you're out there representing another company, you want to make sure that you have the authority to bind them, because you don't want to get out there and get beyond your coverage and be writing contracts for something that the company really isn't backing up, and then find yourself personally liable, or your company that you're working with that you own personally liable for a contract and for doing something that the person you thought you were representing isn't actually bound to. So you can really get out there beyond where you should be as far as representing something and pick up some liability that way. On the other hand, you don't want a lot of people out there purporting to represent you if they don't actually represent you and have the authority to bind you, because if you've given them really the apparent authority to do that, where a reasonable person dealing with that with your agent, who maybe not really be your agent, but they're dealing with them thinking that they're dealing with you, you could find yourself liable for something that someone else has bound you to, because you haven't put in sufficient protections to say that whether or not that person can actually bind you, and whether it's calling someone a partner who's not actually a partner. Being careful about that. A lot of people say, oh, we're business partners, but you're not legally business partners, and you don't want that person out there binding you to anything.
Exactly.
And like you said, Matt, it cuts both ways. You don't want to be binding someone who you think is your partner if you don't actually have the authority, because you might, again, be out there liable yourself for doing something that you thought somebody else was going to pick up the tab for. Exactly.
And then moving on to another topic with this is the mediation and arbitration provisions that are contained in contracts. Sometimes. There's a growing trend towards alternative dispute resolution and making efforts to avoid the court system, avoid litigation and the costs and time associated with it. So a lot of folks are attempting to put mediation and arbitration provisions in their contracts to take this outside of ordinary litigation and go through a less formal process. I would say, I'm a mediator and an arbitrator, and I would say that this is good and bad. It depends. It depends on the type of claim you would have. It depends on the process that you would like to put in place. It depends on the provider you select. A lot of the well-known providers have very expensive fees to file and to prosecute a claim through arbitration, for example. Also, the timing and the administrative side of things, it depends on the provider. It depends on the claim. So I would say that when you're considering a contract that has one of these provisions in it, you need to decide whether or not that type of remedy is an appropriate remedy for your situation under your circumstances.
And I think it has a lot to do, just like you said, about having the right mediator, and someone such as yourself that has experience with business disputes, who has experience with litigation, and definitely somebody maybe that has industry experience in whatever you're dealing with. it's good to have a person like that as the mediator because they are really, if you get the right person, they're more than worth their fee, and it just, they can really cut to the chase. And it's not about splitting the difference. It's not that you come in there and your position is $1,000, the other person says $3,000, and the mediator or arbitrator is going to split the difference and say it's $2,000. No, it's a much more multifaceted thing that goes on in mediation. Big difference. I don't know if a lot of people realize this. Mediation is voluntary. Arbitration is something that you're going to be bound by. But we see a lot of people, and I put mediation into a lot of my agreements. Just especially if you've got people that are on the same side, business partners, and they'll get together and do mediation. So it's a good thing to have in there, and there's definitely a trend towards that.
All right, thanks. Well, I think we're just about out of time, so I want to thank everyone again for joining us for this episode of Planning Successfully. You can find out more about this show at planningsuccessfully.com. You can find out more about Davis, Matthews, and Quigley by visiting www.dmqlaw.com, or you could call us at 404-261-3900. DMQ can be found on Twitter at DMQLaw. I can be found on Twitter at Matthew Theory. Thanks again, and look forward to hearing another show and having you join us next time for Planning Successfully.